Hello everyone, welcome to yet another episode of WeTag, Weekly Compliance Update. I'm myself Pratik, Vaidya, Managing Director of Karma Management Global. As you know, through this series inspired by our WeTag newsletter, we bring you concise insights on court rulings, statutory changes, as well as regulatory development that directly impact your business. So let's get into this week's updates. So first of all, the update number one. This is one important case which is there in Telangana. The Telangana High Court quashes EPF case against company director. So the case was that can a company director be held criminally liable for EPF defaults simply because his designation is a director and his name is there? So the Telangana High Court says no. So in the case of Sridhar versus State of Telangana, it was decided on 1st of May 2026 by the High Court of the State of Telangana. The case which was there was criminal proceedings against the former chairman and managing director, and which were quashed by the EPF default matter. So the court observed that the company itself was not made an accused. There was no specific evidence of the director's personal involvement, and the dues had later been cleared through insolvency proceedings and all. So the court further clarified that criminal liability cannot be imposed solely based on a person's designation. And this is a very important landmark judgment here in the midst of Code of Wages and Code on Social Security. So authorities must establish clear evidence of the individual's role and responsibility before initiating prosecution. Yes, there is an important and the director responsible, but it's not for everything, right? So this judgment reinforces the principle that PF non-compliance must be supported by evidence before criminal action is taken against any of the director. At the same time, the responsible people also need to ensure that the leadership position alone does not automatically create criminal liability, but does not absolve themselves from non-compliance. So that's it, so important. Yeah, so let's go to update number 2 here. Centre assures support for Kerala's retrenched tech workers. Now, what is this? The centre steps in when hundreds of employees suddenly lose their jobs in Kerala. So the Union Labour Ministry, it said that it will assure the full support to the Kerala government in protecting the rights of over almost around 800 retrenched employees. This happened in Coro Health Infotech, which was Kozhikode and Kochi. So the matter is currently under discussion with another round of talks scheduled between the company and the state government. So meanwhile, Kerala High Court has also encouraged that conciliation has to be done to help resolve this dispute. So alongside this, Kerala has sought additional time to finalize its rules because the rules under 4 labor codes are not done by Kerala. So they say that will take time, and highlighting that the balanced industry growth with employer protection has to happen. So the key takeaway is that the development shows that worker welfare remains on the topmost priority and a shared responsibility between centre, government and the states. So as labor reform progress, collaboration and dialogue will play a crucial role in protecting jobs and ensuring fair employment practices. So that's what the important thing is. Update number 3, let's look at that. So you know that EPFO has just had new schemes effective 1st July 2026. Will employers have to contribute more to PF soon? More than 15,000? The central government has deferred its proposal to increase EPFO wage ceiling. They told initially that go up to 50 and 25,000, but right now they are deferred. It's like temporary relief to businesses, especially when the EPF schemes have come up. So both employer and employee now have to mandatory ensure that the contribution is up to only 1,800, not up to 3,000 at all, which is based on 25,000. Which will bring 1 crore additional workers under mandatory PF cover. It's not going to happen. So government has decided to pause the move and hold further consultations. Considering the additional compliance costs businesses are already facing in the new labor codes, so it's kind of delayed a bit. But mind you, it may go up to 21,000 at least, which I said just on par with ESIC. So the key takeaway is that EPFO wage ceiling hike is deferred, not cancelled. It can come in near future. Employers should use this time to prepare for a possible future increase if you're restricting your PF up to only 1,800. So keep close on upcoming policy. Do follow WeTag as well for more updates on that. Let's see update number 4 now. So Labor Code raised compliance costs for businesses. Everyone is complaining on that. Are the new labor codes making compliance more expensive? I would say yes, and businesses are already feeling the impact because employers were having a basic around 35 to 40%, now it's gone up to 50%. The implementation in India's new labor code is expected to rise at least on an average cost or compliance cost by 15 to 20%. And with the IT sector alone reporting incurring over 1,000 crore in additional expenses. And the biggest reason is the new wage definition, as I told. It makes that the basic pay and allowance make up to total about 50% of the cost to company, or you can say total remuneration. So this increases statutory payouts to PF, ESTAG, gratuity, bonus, etc. And top of that, employers must also comply with the new requirements, like they need to ensure appointment letters now are issued compulsorily. They need to have grievance redressal committees or GRC, digital records to ensure, and they need to enhance the employee benefits, all and so on and so forth. And if you talk about MSMEs, they're really grappling up with, and that's the thing. There is no structured way of saying that what can be a best way to restructure salaries, especially for MSME. So there should be something on the payroll structures, HR processes, and compliance to stay prepared. There should be some understanding from government to give, or there should be a tool to be given to them. And I'm sure that really aid them. Let's go into trivia. So did you know the in the OSH code, employer have a voice in the workplace? So under OSH code 2020, every factory or establishment employing 20 or more workers must constitute a grievance redressal committee. 20 and more. It's very, very important. Yeah. So if you do not have a grievance redressal committee, you should put it. So what is important? First of all, it provides employee with a formal platform to raise workplace concern. Yes, HR is there, but now it is under law. It encourages timely resolution of all or any of the grievances before they escalate into any kind of dispute for that matter. Third, it promotes better communication and trust between employer and employee. That's the important part for it. So what are the key takeaways with this? The GRC or the grievance committee isn't just a compliance requirement. It is a step towards creating fairer, more transparent and employer-friendly workplaces. Larger organizations do have HR in place, but small organizations now they need to have, especially more than 20 employees, they need to have GRC in place. So let's look at last segment of ours is like compliance is to be done. So first of all, 20th July 2026, Monday, you need to ensure that PT is paid for state of Karnataka. 25th July, PT remittance and return is filed for states like West Bengal. And that's it for, and I hope that you all have ensured that by 15th of July, states like Maharashtra, you already paid labor welfare fund. So that's all. We have compliance snapshot for this week. These insights are drawn from our weekly newsletter, WeTag, now brought into video format. If you find this briefing very useful, dive deeper into the full analysis via the link in the description box below. Subscribe and like and comment to the WeTag on LinkedIn for weekly insights. Thank you, everyone.